Now, I am going to dictate a legal passage at the rate of 160 words per minute. 5, 4, 3, 2, 1. Start. Let's start. The present criminal appeal under the Supreme Court within the Enlargement of Criminal Appellate Jurisdiction Act 1970 is directed against the final judgment and order dated 2010 in CRLA number 1952/2005 within the hearing after referred to as the input judgment passed by the High Court of Karnataka at Bangalore within the hearing after referred to as the High Court, whereby the High Court was pleased to allow the appeal filed by the state qua the sole appellant panel. The appellant was a co-accused along with one other upon trial. Both were acquitted. However, in appeal before the High Court referred by the state of Karnataka, the appellant has been convicted under section 302(1) of the Indian Penal Code 1860 within the hearing after referred to as the IPC and sentenced to undergo life imprisonment penal. According to the prosecution history, on 03/01/2002 at about 4:30 p.m. an unidentified dead body of a male was found by the complainant within the PW1 in his field, leading to institution of complaint with the police. Later, the body was identified to be that of one Krishna Appa. The allegation is that accused number 1 within the appellant herein, along with accused number 2, with a common intention killed the deceased. The motive steadily being that the deceased had developed illicit intimacy with the appellant's sister. It is alleged that both the accused had further tried to destroy evidence by setting fire to the dead body by pouring petrol. The prosecution examined 12 witnesses, including the complainant of the PW1 and one of the attestates to the inquest panel. Upon trial, the principal sessions judge, Bangalore Rural District, Bangalore, by judgment and order dated 09/06/2005, acquitted the accused of offences under sections 302 and 201 of the IPC, holding that the prosecution had failed to prove that the deceased was last seen in the company of the accused and had also failed to prove the extrajudicial confession panel. Aggrieved by the judgment and order dated 09/06/2005, the state of Karnataka filed criminal appeal number 1952/2005 before the High Court. The High Court, by the input judgment, reversed the order of acquittal passed by the trial court qua the appellant, whereas the appeal against the accused number 2 within the hearing after referred to as A2 was dismissed. The same is under challenge in the present appeal by the appellant panel. Learned counsel for the appellant submitted that the ground for acquittal by the trial court is based on evidence and the reasons given are cogent for holding that the prosecution had failed to prove its case against the accused under sections 302 and 2012 of the IPC. It was further submitted that the High Court erred in reversing the order of acquittal against the appellant, whereas not interfering with the acquittal of the A2, as basically the role within bracket is assigned to both is the same para. Learned counsel for the appellant submitted that in the charge framed by the trial court, it was clearly mentioned that the specific allegation was that A2 was the person who had come to the house of the deceased 2 days prior to the fateful incident and taken him away on the pretext that the appellant's father wanted to meet him, whereas during deposition PW3 and PW8 have stated that it was the appellant who had come and taken the deceased with him. Para. Learned counsel submitted that this very basic aspect, which completely changes the theory of last sin, cannot result in conviction of the appellant, as that is the sole ground for reversal of acquittal by the High Court. It was submitted that the only material to hold that the deceased was last seen in the company of the appellant by the High Court was the testimony of occasion for the deceased to have accompanied the appellant to his house, and that too late in the night. It was urged that the strong point to the falsity of the allegations is the fact that the deceased wife admitted during deposition that even when the deceased did not return for 2-3 days, she had not made any complaint, and a very vague reason for such contact is given, saying that even in the past he, within bracket the deceased, used to go away for 2-3 days. Stop. Thank you. Jai Hind. Jai Mera Bharat.